Yes, Mr. Bates.
Yes, thank you, my lord. May it please you, my lords, I appear on behalf of the appellant, Accent Housing Ltd, and my own friend, Mr. Verdun, appears for the respondent, Howe Properties North East Ltd. Inevitably, at the beginning, I have a few bits of housekeeping. The first is the director of my learned friend's client is running slightly late. There's been train problems coming down from the north of England.
Sorry to hear that.
He's quite content for us to proceed, but if you see someone entering at the back, 20 minutes or so's time, looking slightly flustered from a taxi journey, that's who has arrived.
Well, we had a planning case yesterday in which a large proportion of the population of Norfolk was squeezed in here with people coming and going in very large numbers, so it won't worry us at all.
Well, just for completeness there, so of course my learned friend's client may well be watching on the live stream. In terms of additional housekeeping, hopefully, my lords, you've got the core and supplementary bundles, and I hope you've flagged that the leases, which are the critical documents in this appeal, are in the supplemental bundles. An authorities bundle with 12 tabs in it.
Yes.
Primarily relevant to the respondent's notice rather than the substance of the appeal, but will come up in due course. And just to say, my Lord Snowden, thank you to your clerk for the help with the authorities bundle. Tab 10 proved particularly challenging to get right. So my gratitude for dealing with a quite inordinate amount of emails and phone calls from me to get that into a...
Well, it usually happens that you then won't refer to it, so... All right, good.
And then my own friends handed in 3 loose sheets from Ms. Justice Lewison's book, Lewison on Contracts, that he may want to refer to in the course of this. And then the final matter of housekeeping, again, forgive me if you've seen this already, but in the core bundle at page 67, you may see that costs have been dealt with in advance of the hearing. If I can take you to that.
Thank you.
You'll see during the course of preparing for the case, a consent order was agreed. Paragraph 1, the effect of those 2 statutory provisions referred to, section 20 big C of the 85 Act and paragraph 5A of Schedule 11 of the 2002 Act. The effect of those is that if I have a contractual right to recover legal costs under the lease, I will not rely upon it in these proceedings. And then paragraph 2 is displacing the normal costs follow the event provision, and this court will adopt the same provisions as the lower tribunals. For those who don't keep Rule 13 of the FTT's procedure rules to hand, it's wasted costs or unreasonable behaviour. So unless something very strange happens in the next few hours, the reality is this is a no order as to costs hearing. There are 2 aspects to the case today. The first is my appeal brought with permission of Lord Justice Stuart Smith, and it's a question of contractual interpretation. It concerns management fees under 3 long leases and whether my client's method of apportioning management fees is permissible under those leases. The sums involved are relatively minor, as I'm sure you've seen, £300 per lease per year. But we're a social landlord with this model of lease applying in around 1,000 of our properties, so there are some significant stock management implications for us, as was noted when granting permission to appeal. The second issue is the respondent's notice, and that breaks down into 2 distinct issues. The first is whether the Court of Appeal is the proper place to deal with the respondent's notice. As you may have picked up, below, in the appeal from the FTT to the Upper Tribunal, my learned friend sought permission to appeal on the construction issue that's now before you on the appeal, but also on what I'm going to term loosely, if slightly misleadingly, a reasonableness challenge. The Upper Tribunal overlooked that when dealing with permission to appeal. And when we got to the Upper Tribunal hearing, Judge Cook indicated she'd deal with it on a rolled-up basis at that hearing, but didn't need to because she found against me on the construction issue. So my learned friend still has an undetermined application for permission to appeal on that issue. And it's common ground between us that, subject to your approval, the better way of dealing with that, if we get to it, is to remit then to the Upper Tribunal for it to decide what to do about that reasonableness point. Maybe to grant permission and hear it itself, to grant permission and remit it to the FTT, or to refuse permission. My Lord, I see you drawing breath, suggesting I've lost you at this early stage.
No, I think that clearly all of this is contingent, as you say, on the appeal itself. But we'll want to think if we get to that point, and we'll want your help, even if the appeal was not to be successful, but so that we can have everything in view as to whether it's more appropriate to remit to the first tier tribunal or to the upper tribunal.
We'll deal with this in due course, because obviously both of us do come prepared both to argue and to assist more generally. Yeah. I think it's common ground that logically you'd remit to the upper tribunal, because it's the upper tribunal that hasn't yet determined whether there should be permission to appeal on that point.
Well, yes, but isn't that rather a long road? Why, if we got to that point, is the upper tribunal in a better position to decide on whether there should be permission? I just throw out the fact
no, of course.
That if we got to the point where you had made progress with your appeal, then the question of we need to consider whether there's a remitter. I'm sure that you're both right that it's not for us to be starting to embark upon what you described, as it were, as a reasonableness discussion, because there are important issues that would arise within that. But query whether it's right to remit to the upper tribunal or to the first tier tribunal. So can we leave that for the moment, so that you can zoom in on it, both of you, in your submissions?
Of course. Well, let me just put my cards on the table for that a minute. Malone & Friends' client is plainly entitled to determination on that question. It's been raised, it hasn't been grappled with yet. Someone has to grapple with it. The question of forum is very much a secondary one.
Yes.
Save that I think where we are common ground is it's not realistic or proper use of your resources to expect you to start doing effectively the first instance.
Can I just ask you a factual question?
My lord, yes.
Which I couldn't work out from the papers, which was the figure that you came up with of 304. Was there any workings behind that, saying we had £20,000 worth of employees, we added a percentage for profit which we're entitled to under little d, and we then divided it amongst the properties in this way, which we can...
No, I'll take you to what there was below, and it's that absence of workings that is probably one of the reasons why one would want to remit for consideration on that point.
Absolutely, because I mean the service charge, whoever is right between you, does have to be on actual figures, and at the moment I couldn't see where they came from. So it didn't surprise me that this did end up in the tribunals.
So I'll take you through what there was below to answer that question, but the short answer is the kind of document you're looking for doesn't exist here.
No, okay.
But would that be a reason to remit it to the first tier tribunal as the basic fact-finding tribunal rather than the upper tribunal?
Quite possibly. Again, let me be cards on the table on this one. Whether it's the upper tribunal exercising its rehearing powers, or whether it's the first tier tribunal de novo, is in danger of becoming a how many angels on the head of a pin question. I accept Malone Friend's entitled to raise these points. He's entitled to decisions on.
I think one of the things that would might inform this is, I mean, you both no doubt have a feel for what it is that the first tier tribunal does day in, day out, and what it is that the upper tribunal does day in, day out, and you'll be able to probably situate the sort of issue that arises here with reference to which is the, as it were, the source of the greatest degree of knowledge of these issues.
Reminding myself that a few minutes ago you asked me to move on from this one, I'll answer that very quickly and then move on from it. This is classic first tier tribunal territory. This is what the first tier tribunal does day in, day out. Look at the figures, see how they fit in with the lease, apply its expert knowledge to them, and come to the reasonable figure.
Mr. Vidal.
Yes, I hesitate to rise when my learned friend is speaking on that, but I want to endorse just what he said, partly because there is, of course, a fourth lease in relation to this matter for which there is not an appeal and which has been remitted to the FTT for investigation into the reasonableness of the £300 charge. So there's out of a sense of proportionality, it would make sense if all of those were dealt with together, and so it would be the respondent's point of view that the FTT would probably be the preferable venue for that reason. Otherwise, we have hearings in the FTT and hearings in the upper tribunal, which might be touching upon the same thing. Obviously,
and indeed, because these are houses on the same estate and will share some common items of expenditure, there may be some interplay between the decision in relation to, for example, the lease, which has an arithmetical 137th division, and on this hypothesis, the leases that are the subject of this appeal.
My lord, yes.
Right, so while you're both on your feet, can I just check that I've understood that that if, and it's clearly what we're now about to think about, the appeal succeeds, then the consequence would be that the issue of the reasonableness of the service charge would be remitted to the FTT.
I think that must be right, yes.
Yes.
And so it covers the respondent's notice
Yes.
points. That's very helpful. Thank you.
So, having dealt with that slightly out of turn then, I think that probably shortens what I need to address you on, because then I only really need to address you on the appeal. Because if you're not with me, the response notice doesn't arise. And if you are with me, there's now consensus at IDEM that the answer is send it back to the first tier tribunal to have them grapple with the issues upon which we accept and then friends entitled to a
And when you remit something to a first tier tribunal, is there an issue of who it goes back to? Does a first tier tribunal of this kind reform in the same constitution, or is it just a random matter of allocation?
There's no hard and fast rule whether in
Right. Well,
underlying
you'll think about, if we get to this point and if you came to be drafting an order, whether it's appropriate that it should be the same or different.
the normal practice in my experience is it's remitted to the first tier tribunal for directions, and one often asks the president of that chamber, well, this be the president of the northern panel of the tribunal, to consider composition, because it may well be that the members aren't available who did the original case.
Quite. Well, but if there was any, in principle, thinking about that you wanted to raise, then you should raise it with us before an order is signed off, if we ever get to that point. Yes, right.
That's very helpful. Right, in that case, then, with that housekeeping out of the way, let me turn then to the merits of the appeal. And essentially, there are two areas I'd like to address you on in setting out the appeal. The first, although this is a very short appeal, I would like to spend a few moments taking you through the background material, the FTT decision, what material there was explaining how the £300 figure is reached at, picking up on my Lord's question. But then the meat of this is looking at the leases. And what I will do is take you to one lease, identify where the other two in the appeal differ. I don't contend, and I don't think my learned friend does, that the differences between the three leases in this appeal are significant, as opposed to the fourth lease which isn't appealed, which has a fixed percentage figure. I would hope I can do the appeal in an hour and a half. I think we're both hoping we can do this before the short adjournment.
Yes, by all means.
Thank you very much. So, in order to set the scene then, can I start with the FTT's decision in the core bundle at printed page 89.
Yes.
And you can take paragraphs 4 to 7 as the tribunal's summary after its site inspection of the estate in question that we're grappling with here. You see there's some 138 flats and houses. Just pausing for a minute there. Of course, it's been noted that one of the leases refers to 137 for the denominator. As we explained in the Upper Tribunal, it's because there was originally a caretaker flat. That's become an assured tenancy now, so it's rented out, it produces income in the usual way. So now 138 is used. A mixture of houses and flats, and a mixture of tenures, some freehold, the majority assured tenancies, so traditional social housing, and 31 let on long leases which expire in 2112. This is a low-rise development with nothing above 2 stories. We see from paragraph 5, it's an extensive physical estate with grassy areas, trees, shrubberies, a stream. Most of the roads and footpaths have been adopted by the local authority, but certain flagged footpaths and flagged parking bays fall to be maintained by my client. And then paragraph 7, It's an estate that's in good order. Ivy has been cut back from the walls, the trees, and the
We've read
handrails.
this and we can see all this.
Yes, I'm grateful. Now, obviously, we incur costs in managing that development, and the tribunal dealt with those at page 98, paragraphs 31 to 34. Now, paragraph 31, it records that the primary argument for the leaseholder was that service charges for management should be around shouldn't exceed 15% of the service charges for the year. What we actually charge is £300 per year, and her case was that they were not worth £300 a year, i.e. not a reasonable figure.
£300 to that particular tenant.
To that particular tenant, yes. So for the 4 properties here, 4 times 300 per year is the charge.
So what's the first sentence mean?
The applicant claimed that the annual management fees charged should not exceed 15% of the charge payable for the year. So the leaseholder's primary position at trial was put the lease to one side for the moment. They said they should pay a management fee calculated by reference to a percentage of the rest of the service charge expenditure. So you total up all the normal service charge costs, the insurance, the repairs, etc., and then you add 15% on that, and that would be a reasonable management fee. That was their answer.
So it's a way of calculating it, which would mean that you worked out what was actually spent, and then you added 15%.
Exactly. Yes.
Yes, I see.
And there were arguments below about other estates where this has happened, analogies with some of the social housing tenancies where it's calculated.
Hang on, I understood. So wait a minute. You say put aside these. I understood. Maybe I'm wrong. That when we were talking about management fees, we were talking about subcategory D.
Yeah.
And what was said is that they shouldn't be more than 15% of the whole of clause 5.2, annual service charge as defined.
I think I understood it as being the totality. I mean, it's a slight red herring because, of course, on any view, that's not what the lease says.
No, but it's.
So,
I thought that was a comparison between sub-item D, which is you could loosely refer to as management charges, and service charges, i.e. the annual service charge as defined, subparagraph 5.2, i.e. the whole.
How I've just explained it is how I understood it to be. If it's a slightly different point, I don't know if my learned friend can pick up on that.
But I'm not sure it really matters.
No, quite. But
Oh,
for
okay.
what we're grappling with today, we're still very much at the background stage. We'll come to what the lease means, because it means what it means.
Right, but the £300 that's been identified, to pick up my Lord's point earlier, that was allocated in some way to, as I understood it, subparagraph D.
Yes, and it's charged under subparagraph D. I'll come to the evidence as to how it's produced in a moment.
Right, okay.
So, but just carrying on with the decision, I don't want to try the court's patience. Paragraph 32, we produced an explanation of our tiered charging system. I'll take you to that in a moment and try and explain how we came to these figures. The tribunal noted it was in accordance with the current RICS guidelines. They noted the leaseholder hadn't shown that a lower fee would be charged by any alternative manager. They reject a comparison with social tenants because the underlying legal framework is not the same. They consider the £300 that we do charge is within the spectrum of reasonable charges for the work undertaken. And then paragraph 34, the first sentence thereof, their ultimate conclusion is that we manage it to a generally high standard. So,
Can I ask how, in practice, this works? How often are service charges levied?
annually.
Annually in advance or in arrear?
In advance, we can look at this in clause 5.1 in a moment. The lease requires in advance with an end of year reconciliation.
Right.
Turning then to how we get to that £300, in the supplemental bundle at page 151, you have the material we put forward. It's a witness statement from Mr. Whitfield, who was the home ownership manager of the appellant in this case. And it's his paragraphs 5 to 8, and then I'll take you to the exhibit he refers to as well. So he explains in paragraph 5 that we introduced this system of tiered charging in the 17-18 financial year. And the fees are calculated by reference to the type of scheme involved, so the type of property you're managing, and then the level of services provided in relation to that kind of scheme.
And he's using the expression management fee in the context of the lease as a 5.52D.
52D, yes. Yes.
Yep.
He explains there are 5 tiers. I'll take you to the exhibit he refers to in a moment. Paragraph 7, he explains the fee is 300. We offered to make it 150. That was rejected. And then he explains at paragraph 8, he starts to give general descriptions of the items of work that are carried out for the £300. His exhibit starts on page 156.
Before we go to that, I think this is presumably obvious to specialists, but this case has not been particularly about the tiers of charging for different types of tenure. Is that something that is, for example, if one looks at the RSES material, is that an acknowledged way of dealing with service charges?
So let me answer that at two levels. The RSCS's service charge code is approved by the Secretary of State under, I think, section 93 of the Leasehold Reform Housing and Urban Development Act 1993, and it represents good practice. The Upper Tribunal has said that we are to approach it in the same way one approaches public law guidance. So it's the best practice, you start from it, but you can deviate if there are appropriate circumstances. Now, my learned friend points out in his skeleton, and he's quite right about this, the RSCS code doesn't apply to social landlords. It's a code aimed at private landlords, not social landlords. It's still a good practice code, but it's not aimed at social landlords. That's because social landlords are regulated in a very different way. The regulator of social housing has the statutory responsibility for regulating social landlords, both in their capacity as landlord under a long lease and in their capacity as landlords under assured tenancies. And the regulator of social housing produces a variety of what are called the standards that one is expected to meet. If you fail to comply with the standards, then depending upon the severity of the breach, you risk a range of sanctions going from a warning letter to potentially being intervened and having your stock taken away from you.
As I understand it, this estate includes both types of housing. So you are potentially subject to 2 guidance codes, for want of a better expression, one of which has some teeth and the other one doesn't.
Quite. A nice simple way of putting it, yes. It's 3 tenures on this estate. We have some people with freehold houses, so they contribute to the communal parts by way of a rent charge, which is what you call a freehold service charge. Then you have leasehold flats of properties of the one sort we're looking at here. Predominantly old right-to-buy leases that have just come over to us as part of stock transfers. The regulation of those is through the social housing arm. And then you have the assured tenants, the traditional social housing tenants, much more detailed regulation via the regulator of social housing.
So to put it bluntly, the management, what's involved in the management of these different types of properties, sorry, these properties which may be held on different types of tenure, could vary.
Quite. And
so that, if you had 3 identical houses but held differently, the maintenance, or the management of those properties, for want of a better expression, might vary both because of the condition of the properties, which has got nothing to do with their tenure, at least one would hope not, but it may also, in terms of management functions, might differ according to the nature of the tenure.
You can actually go further than that. Not only may vary, will inevitably vary. And one of the examples you may have seen touched on in the pleadings is to do with repairs. So if you're an assured tenant of a housing association, or a weekly rental tenant in the usual social housing way, you have the benefit of the implied repairing duties in Section 11 of the Landlord and Tenant Act 1985. The landlord will repair the structure and the exterior of your building. Critically, he can't charge you for that. He has to pay for that out of the rent. The rest of the 85 Act prevents you charging rental tenants for repairing their building. That's what your rent is for.
Is there any place in which the intricacies that you're explaining to us now is actually set out?
In this material for this case, no.
Just short of taking it down at dictation speed.
No, quite. I'm happy to produce with my own friends agreement headline note on the major differences between them. But the answer I was just the main textbooks don't.
Since it's part of your case that different tenures, different types of tenures, not length necessarily, but types, involve different levels of management. You putting it neutrally. It would be certainly, for my part, useful to understand the basis upon which you, or an illustration of the basis of that, because leaping ahead a little, if you were right in your question, in the answer that you want us to give to your question, namely, does the lease prohibit a move away from an arithmetical equal proportion in relation to these annual service charges and in particular the management charges? I don't think it's part of your case that can just be a figure plucked out of the air.
No, and I think I'm happy to do that. Indeed, I'd actually quite enjoy doing it. But
that's a very dangerous concession to make.
No accounting for taste.
No, I was thinking the very thought. I mean, I think that this is quite it's quite basic stuff, but it's which is clearly known to you, but not to the same extent to us. And so I think to have a short note, which you're both happy with, which simply gives the main contributors to the situation, legally speaking, would be very helpful.
Quite happy to produce that.
So that would, in a sense, be a non-partisan note, which is simply just explaining what the context is.
Of course, and I'm sure we can. I'm sure we will do that. But just to pick up on where this would come in, perhaps to make clear what I'm arguing on the appeal. At the moment, I've lost on the point of principle that it's simply not permissible to have this tiering system whereby things step back. The way we charge our service charges to Malone and Friends client is that we total up all of these things we incur. So for repairs, you go and get the invoices because they're external figures. For the reserve fund, the lease tells us how we make an informed estimate for future years. And for management, we put £300 in the pot for each of his properties. We then have that total figure, which the lease calls the annual service charge. And then we charge an amount of that overall figure to Malone and Friend. The different elements of that outcome amount aren't calculated the same way. So, for example, when we charge him we charge him 1/138th per property for the repairs, let's say, because we do all of the repairs on the estate basis. But for the management charges, he gets charged £300. At the moment, I've lost on that as a point of principle. At the moment, the Upper Tribunal says you can't do that. You take all of the costs, whatever they are, you put them in your pot, called the annual service charge, and you must split it 1/138th way.
But if you win on the point of principle that you can depart from a 1/137th or 8th share of the pot, as you put it, that doesn't then necessarily mean that you can just do whatever you like.
No.
And that's where this will come in, because, and it's not, as I understand it, for us, but it will be for, on this hypothesis, the person to whom this is remitted, to say, well, is the way that you have charged whatever scheme you have put in place reasonable, in fair or proportionate, depending on which word it are, which word it is, and certainly speaking for myself, my concern is that it's quite important to understand at least what that second stage would look like if we're to accept your proposition as a matter of interpretation as to what the first stage outcome is.
Quite, I agree with all of that, my lord. It was what I was wanting to make clear, and thank you, my lord, you have. I agree that the place for that detailed analysis of if in principle we can depart, is our actual method of departure still within the scope of the lease? That's one of the issues I know my own friend wants to challenge, and that's one of the things that would arise on remission.
Yep.
Because it still has to be a fair, a proportionate, or the statutory language, a reasonable sum we end up with.
But we've been talking about departure on the basis of tenure. I mean, what you don't get, as I understand it, in anybody's world, is departure on the basis of tenant. So when one's talking about what is reasonable, what is proportional, what is fair, you're obviously looking at it from your point of view, namely you want to cover your bills, taking the estate as a whole. But you're always going to get situations where, for example, most of 95% of everybody's time is spent on 5% of the people, and so most of the expenditure for certain things will go into a very few properties, but other people will end up paying part of the service charge for those. Is that not the way that it works? I mean, if you paint the front of one building, does that, or if anything that goes into as a service charge, is it charged building by building? Is it charged block by block? Is it charged across the estate?
No, it's across the estate. And
So that means that you may have somebody who never sees anything from one end of the year to the next and has to pay the same amount as somebody who has the builders in for most of the year. That's the way it works.
Exactly, and if we take a more common vertical block of flats, that's the scenario you get when the person on the ground floor resists paying for the lift. They say, well, I don't need it.
Yeah.
So, and that's where the tribunal kicks in, because the tribunal still has to be convinced, if in the event of a challenge, that what we're doing fits with the lease and then fits with the statutory protection.
But to take my lord's point, I mean, what he's really saying, I think, is there will always be swings and roundabouts from year to year between properties and tenants. In one year, somebody's property could be entirely free of any problem whatsoever, whether on a management or physical problem. In another year, there may be a flood which affects one part of the estate rather than another, and there will be people who are affected. But the question is whether a swings and roundabouts approach, if that's what you adopt, is reasonable, fair and proportionate.
Right.
But that is, if permitted, not for this court, but for remittal.
Quite, yes.
But you would have to justify that.
Yes, I agree. Yes, I entirely agree. It's not open to this landlord or any landlord just to say, this is what we do, lump it. But the whole point of the statutory intervention since the mid-1970s has been to have now the first-year tribunal property.
And then to take another example, if you chose a metric by which to allocate the charges that had nothing to do with the purpose for which service charges are levied, in other words, everybody who has a green front door pays more than everybody who has a blue front door, just because we don't like blue front doors. Green, whichever way around it is, yes. That would be, on the face of it, perfectly capable of application, but it would be unreasonable.
Yes,
not fair.
I have no difficulty the tribunal in that circumstance, by one route or another, could intervene.
But that's all for another day in another tribunal.
Quite, yes.
But it would help to understand both what controls there are externally on those sort of charges in the memo that you just described.
Yeah, that makes sense.
And you accept, I think, that there has to be some justification offered at stage 2, assuming that you're right on your point of interpretation that it's permissible.
Quite. Yes, I do accept all of that. It's perfectly open to a leaseholder to say in the first tier tribunal that charge doesn't comply with the terms of the lease, which is the argument here. You haven't calculated a charge in accordance with the lease, and if that's right, then no charge can be made. Normal contractual interpretation. It's also open to them to say, well, I accept it's contractually due in principle, but then the Landlord and Tenant Act 85 intervenes and says I only have to pay for it if it's reasonably incurred and reasonable in amount. Well, it wasn't reasonably incurred. You did no market testing. It's not reasonable in amount. It leads to me paying 95% of a service I never receive. That's the day in, day out work of the first tier tribunal property chamber.
Yes, I was just looking as you were going to take us in due course to the lease, and this refers to the service charge being your expenditures in relation to the buildings.
Yes,
which is the.
And the building is defined as the
Entire estate.
the entirety of the estate. It's
So
a slightly roundabout definition.
You're not going to succeed in the first tier tribunal complaining about a service charge simply because it wasn't on your property.
No. But you might succeed on the statutory gloss. For all service charge cases, you always have those two arguments as a tenant. The starting point is always the lease. If you haven't charged in accordance with the lease, it isn't payable. And the same as any contract. If the contract requires it, the demand to be on blue paper on a Monday and you submit it on orange paper on a Wednesday, it's not payable yet. It's the same as any contractual case. If you get over that, then you have the statutory gloss. And the primary statutory gloss is the reasonableness jurisdiction. So the tribunal will need to be satisfied it was reasonably incurred, which is about the process by which you came to incur this cost. Did you test the market, etc.? And if you did, was it reasonable in amount? Because you could have a cost that was procured perfectly with wonderful market testing, but if the actual quality of the painting is rubbish, then you should only pay the value of what you've received. So those are the protections of the service charges. But I'm sure the two of us can produce a guide to that without too much difficulty. What I did want to do before getting to the leases was look at the exhibit to Mr. Whitfield's statement where he does explain how this tiering system works. And it's page 156. And you should see there that what we have on the left-hand side are 5 tiers of property within our whole portfolio. The cheapest tier is tier 1. And if you read the 3 bullet point descriptions, you'll see that the gist of tier 1 is effectively standalone properties. So, for example, a freehold house or a bungalow with a very small estate, or the first entry, leasehold or shared ownership houses and bungalows with no estate charges. And then tier 5 is the most expensive. And at tier 5, you're getting towards the supported or sheltered housing end of the market. We're looking at properties where, for example, there's bungalows for the elderly and there's a house manager, or a flat for the elderly and there's a house manager. Domus bungalows, Domus is a management company that we control. So again, bungalows where there's a house manager. And these properties we've put in the middle at tier 3 because they're leasehold flats or maisonettes.
I mean, if you're right on the interpretation, you will have to justify this by reference to the particular buildings on this particular estate.
We still have to justify why £300 is a reasonably incurred and the reasonably incurred amount and represents value for money. That's the statutory question. It's always it's reasonably incurred.
Yeah, but under the terms of the lease, you'll also have to justify why, by reference to this estate, that particular charge in relation to any particular property is fair or proportionate or whatever the expression is.
Yeah, yes, and that's partly what the second part of Mr. Whitfield's evidence before the tribunal went to. It's in that same bundle at page 158. He identified the services.
Yeah, but if, for example, on this particular estate, the particular buildings in question, some of these items just didn't apply for whatever reason, then there might be a tenant might be able to say, well, it's just not. You may think that's appropriate, but it just doesn't apply to this particular estate, these buildings.
I accept all that. Reasonableness challenges are inevitably very fact sensitive.
No, my point is not a reasonableness challenge, to use your thing. This would be a lease challenge. You still, as you said, you don't even get to reasonableness unless or until you can show it is either, quotes, fair or proportionate, within the meaning as a whole.
And I accept, I think it's probably me not following properly. I accept that if anybody says for any particular charge, prove that I have to pay it under the lease, we have to do that. Yeah. We have to identify the clause that we say entitles you to the charge, and we have to say why it falls within it.
So the 5 tiers apply across your entire estate?
Across our entire stock, some 20,000 odd units.
Yes, and how many sites are you present on?
I don't know. I don't think we had any evidence on that.
But I mean, a tenant on this particular estate would be entitled to say, well, look, it's all very well you, for your own administrative and other convenience, taking this view across your entire portfolio. But actually, when you look at this particular estate, it's just not a rational basis for doing it.
Yeah, I accept that. Yeah.
But I mean, it may or may not be. But it's for you to justify it.
Exactly.
But you need to justify it by reference to the particular lease of a particular property on this particular estate, and then subject to the reasonableness.
I completely agree. And that's why service charge challenges are, for the most part, so fact specific. What does this lease mean in this case? What's reasonable in this development? It brings us back by a slightly roundabout route to one of the reasons that neither of us are urging that you go down this route, because it's such a fact sensitive case, and it pick up on my Lord Snowden's question earlier. This is the meat and drink of the tribunal. It's why they go and do site visits. They get a feel then for what they're talking about. They get a feel for how big the estate is. It's why they're an expert tribunal. They build up their knowledge of, well, what is the going rate for gardeners in this area? What about other developments? How many hours do people spend on it? That's what this tribunal does. It's that repository of local practice and knowledge. But just so some of the material there that was produced as to what we do. Many of the bullet points I would accept are largely generic, but to draw your attention to the last entry starting in addition to the above, because of course there was an inspection once a month or more frequently if required, and estates officers who were visiting the scheme to inspect the estate services. Which then brings me, I suspect to everyone's relief, finally, to the leases, because that's really where the appeal needs to be held.
And just to confirm what I think you indicated at the beginning, that was as much as anyone was told about the way in which this part of the service charge has been calculated.
That is the documentary material that was submitted.
No one said, and this covers these wages and.
So there was oral evidence on this, but the tribunal hasn't recorded the outcome of that, hasn't explained what weight it attached to this, and I can't remember, B, it's not proper to try and tell you what was said, particularly as my learned friend didn't do the trial. That is the extent of the written material. There was oral evidence, as the tribunal has outlined, but in the absence of them recording what they heard and what they thought about it, I don't see that I can take that any further.
No. They seem to have gone straight to the issue of reasonableness without actually considering whether you'd incurred these fees. And
So, and this, again, you may have picked up on this in the Upper Tribunal's decision. This was part of an argument I had with my learned friend below in front of Judge Cook.
yeah,
I said this represented an unacceptable change of case from below, and Judge Cook said no, it had all been properly pleaded out below. It wasn't my learned friend's fault the tribunal hadn't dealt with it. So I agree with you. The tribunal focused on the reasonableness question.
yeah.
For what it's worth, Judge Cook thinks they missed a trick there. We think the case shifted. It doesn't really matter for today's purposes, because if we get over the contractual interpretation stage, we're going back to look at all this and to look at this by reference to the various points my learned friend's taking here, because he takes the point my lord is making. Prove these were incurred. Then he says prove they're reasonable in amount as well. So that's why I accept we'll get into all of that, but only if I win the contractual interpretation question.
Yeah, but there is an immediate point, which is what I was trying to get at. Assume you are right that the lease permits you to adopt something other than an arithmetically equal proportion approach, which you are bound in the non-appealed lease to do. Then, as a matter of the lease, there's still the question of what, as it were, by what criteria the charging is fair or proportionate, whatever the expression is. And that's before you get to the reasonableness.
I agree, yes.
So when we are looking at the question of whether you're right that you have the contractual flexibility, it's helpful, I think, for myself to understand how it then plays out at that intermediate stage. Not touching the reasonableness at all, but you know, what does fair or proportionate mean, for example, if those are the two words?
Yeah, that's helpful. I'll try and pick that up. There's obviously a conceptual overlap between a contractual requirement that it be a proportionate part or a fair part, and the statutory requirement that it be reasonably incurred and reasonable in amount. You can see how the same factual material could be relevant to both. Could something be fair but unreasonably incurred? So the factual evidence might speak to both of the questions one has to grapple with. But for the purposes of assuming I succeed on the appeal, and in principle I'm allowed to do something other than the straight mathematical split, I agree, and I hope I'm making this clear, I agree that I'm going to have to explain how my charge fits within the contractual framework, which is clause 5.2d and 5.1, because it's 5.2d that identifies the items, but 5.1 is the actual obligation to pay. And then I'm going to have to grapple with the statutory elements. So I don't dissent from that at all. What I am reluctant to do, primarily because the material isn't here, is go into great detail into what our thought process is, because the material that was below is all you've seen. That's why, if we get to that stage, it's a remission question.
Well, could we at least be confident that by the time we've finished today, if we were to decide that it was to be remitted, that we have very clearly in mind what questions it is that are being remitted? I mean, we've discussed now to the FTT what exactly the questions are, so that we don't leave them to have to wonder what it is that is being remitted.
Right. I don't presently think that would be particularly difficult,
No.
because it depends on the level of detail one wants to go into. The first question would always be, does this charge fall within clause 5 of the lease, which would require, which includes but is not limited to the, is it a fair proportion, a reasonable proportion, etc. If it does, what impact, if any, does section 19 have, which is the reasonableness jurisdiction? But again, we can perfect a form of wording for that stage.
Well, again, I realise it's jumping ahead, as we all made clear, but I think that rather than simply lazily saying remitted to this tribunal, I think it might be helpful to the tribunal to have defined what is being remitted if that state was reached.
I very much tend to agree, because it will focus the mind for what material is actually required, and it will make the job.
Yes, because in some ways these issues give rise to quite profound questions of the nature of the service charge, the extent to which, when it comes to affect a national business in a local context, and so forth.
And again, as I hope we made clear, both in seeking permission and in opening, the Housing Association isn't here today because it's fighting about £300 times 3. It's because we have 1,000 properties with this model of lease, and we need to understand what we do. Because if we've been doing it wrong, which is entirely plausible, we obviously need to change. But if we've been getting it right, then the fact that we have greater flexibility than the Upper Tribunal suggests is equally important to us, given that we have to manage this development for the next, remaining 100 odd years or so. Can I then move to the leases? And what I'm going to use is the lease of 84 The Meadowings, which is in the supplemental bundle at page 27.
Page
27.
Thank you.
Hopefully. It should have in manuscript 84 Meadowings in the top right hand corner. And the critical provisions for the appeal, it seems to me, start in clause 5 at page 41, which is the charging and payment covenant. And you see at clause 5.1, the obligation is on the leaseholder to pay to the landlord annually a proportionate part of the annual service charge, as hereinafter defined, payment made as follows, and this picks up on a point Lord Snowden asked earlier. A is how you dealt with it during the first year of the lease, and we can ignore that because that's some 20 plus years ago. B and C. B is an on-account payment with end-of-year balancing at C.
Yeah, I think it was actually Lord Justice Jackson who asked you about payment.
Oh, I'm sorry.
But yeah.
I'm sorry.
Yes.
And that, it won't surprise anyone to learn, is perfectly normal. That's a very, very common methodology. Estimates and then reconciliations. So, the first thing we need to know in my respectful submission is what is the annual service charge, because that's the thing that has to be split so that a proportionate part is charged to this leaseholder. The annual service charge is defined on page 42 in clause 5.2. And it is the total of all the sums actually expended or provided, either directly or, as in the case of a service by the landlord's own staff, indirectly by the landlord, during the period to which the relevant service account relates, effectively the financial year, in connection with the management and maintenance of the buildings. Buildings, as we touched on earlier, if you jump back to page 29, actually means a lot more than buildings.
Well, it's the entire registered title. It's just done by reference to a registered title. It's exactly the same.
Exactly. Thank you, my lord. Yes, that stays up there. So that's what the annual service charge is. It's the total of all the sums expended, provided directly or indirectly, in connection with the management or maintenance of buildings is misleading. The entire estate is what it means. And then it gives us examples in particular, but without limiting the generality of the foregoing. It gives us 5 examples. The first, A, is in very broad terms the repairing covenants. Those clauses are mostly to do with repair of the building, etc. Not exclusively. In 2A, so looking at it here, you see the references to sub-clauses. Sub-clause 5 is about taxes and such like, so you reimburse them for have to reimburse the landlord for the taxes is due. 6 is potentially relevant. If you jump back to page 39, this is clause 4 sub 6, which gets charged under this heading. This is our requirement to engage, employ and discharge wages and salaries of staff, who else from time to time shall be reasonably required for carrying out maintenance, repair and other works to the parts of the building where those parts are used in common and which are reasonably required for the proper maintenance, running and management of the flats, parking spaces and the grounds of the building. B, on page 42.
Just out of interest, I think from what you said earlier, is this right that some of the items in 5.2a repairing covenants are not capable of being included for certain types of tenures?
Yes. So, taking a step back for a minute, if my lord were to rent one of the assured tenancies here, you would have a tenancy agreement specifying a rent. It may even specify a service charge as well. We couldn't charge you as an assured tenant for repairing the outside of your building because the Landlord and Tenant Act prohibits you from charging rental tenants for that. That's what rent is for.
So by definition, the tenant under this lease will inevitably be subsidising. Is this right?
No, pays in a different way. It's because when it's a rented unit, the rent has to cover all of this. So even if you're a social landlord, your rent includes an element of money you have to put aside to repair the building.
That will doubtless be explained in the note.
It's precisely because the easiest way to think about it. Rental tenants are meant to pay rent and not really anything else. There are some scenarios where they can pay service charges, but really rent is what's supposed to cover everything. Leaseholders are different because they're staying in their properties for hundreds of years, because it's a tradable asset, because ground rent, these are right to buy leases, so ground rent was capped at £10 anyway, so you couldn't make any money off it. It's in my submission fundamentally unhelpful to try to equate or equiparate the way you manage social housing stock, i.e. rental tenancies, with the way you manage long leasehold properties. That way leads to all manner of mistakes that social landlords make all the time because they're regulated so differently.
Yeah, but the point I simply was making is that because this lease covers the total of the sums for managing everything on the estate, which will include social housing and non-social housing, on the face of it, this, just prima facie, this tenant is agreeing to pay as part of the service charge a proportionate part of a annual service charge, which includes the whole.
Yes. Yeah. So let's.
But let's not get. Okay, I don't want to get too deeply into that because that is really heading down a justification route. Just so I understood it.
It's because they're doing different things. This leaseholder is paying to discharge the duties under the lease. Tenants are regulated differently because tenants have a variety of statutory rights which Parliament has said can't be charged for. That's why it's very dangerous.
Tenants under social housing.
Yes. I understand the point you're making. The point you're making, I think, is, well, look, if you incur £1,000 managing the estate, let's say, this leaseholder pays a proportion of that. there isn't an equivalent line entry in the running account of the rental tenant showing what they pay.
Social housing
Yes.
tenant.
And the answer is yes, that's right. Because the cost of managing your social housing stock comes out of the rent you receive, not as a charge to, not as a bespoke charge to your social tenant.
But that will have to be dealt with, frankly, assuming you have the flexibility. You'll have to. That will be part of the equation that you'll have to explain to the FTT.
Very, very, very much so, yes.
Yeah.
And at least in headline form, hopefully, to my lords, as to the differences between them. So this is the identification of what is the annual service charge. In my submission, the annual service charge is those first 5 lines of clause 5.2, i.e. the sums actually expended or provided directly or indirectly in connection with management or maintenance of the estate. And then we have examples. Example A is largely but not exclusively repairs. Example B is the communal television and radio system. Example C is the cost of complying with notices, etc., from the local authority, the fire brigade, as the case may be. Example D is the one that's most relevant here, because example D creates 2 kinds of management fee.
Just pausing there, just before we get to D in great detail, just picking up B and C. Certainly, let's look at B. I mean, by almost by definition, that's a line item, a cost, which it would be difficult to apportion conceptually, fairly or proportionately in any other way than just a straight arithmetical amount, because everybody has access equally to the communal aerial.
Quite.
And somebody wouldn't be entitled presumably to come along and say, or they might come along and say, well, actually, I never watch BBC. I'm exclusively satellite dish on the side of my house, and I only watch satellite. Therefore, why should I pay for the communal aerial? To which you might say, but everybody has equal access, and it's your personal choice. Therefore, we just apportion that equally.
Right. And then the tribunal would make its decision, and for what it's worth, I think you'd win that. The tribunal would say, well, how else are you proposing to do this? We can't possibly keep track of how many hours.
That's how that very simplistic sort of challenge would go.
Yes. Very, very, very much so. But with something where it is capable of individual apportionment, you might have more chance of success.
Yeah.
But
So
certainly,
that,
yes.
so that, for example, if half of the estate actually wasn't connected to the communal television and radio aerial system, but half of the estate was, you might have a more uphill task in persuading the tribunal that it's within the scope of this lease
Very much so.
to enable you to charge equally all buildings on the estate.
Yes, if as a question of fact, you were a leaseholder in a building which did not have a communal television, it would be very hard, I think, to persuade the tribunal that they should be charged a proportionate part of the cost of it, because they could never benefit.
Yeah, it wouldn't be either fair or proportionate. This is the word. I mean, as a matter of interpretation of the
Quite.
lease.
Yes.
Yeah.
But even if it were, you'd then get to, well, does reasonableness change the position as well?
Yeah.
So D then being the management charges. And there are 2 kinds of management charge envisaged. The first is where an external agent is used. And this is all fees, charges, expenses and commissions, but not including effectively letting agents' commissions or estate agents' commissions, payable to any agent or agents from whom the landlord may from time to time employ for managing and maintaining the buildings. And all salaries and other payments made to staff and employees of the lessor where works are undertaken by its landlord without the employment of an agent, including an element of profit to the landlord. So we're in that second half, because it's our staff. So what we're allowed to put in D is salaries and other payments that we make to our staff.
Hang on, you're actually allowed to put into the entirety of this anything that falls within the first 5 lines of 2.
Yes.
This is just happening to express a particular example, but without limitation.
Exactly.
And it wouldn't stop you, if it was cost effective to do so, for example, to employ an agent under the first half of D to do something which could be done more cheaply and more effectively than your over salaried employees.
I agree. Yes, I completely agree.
Allegedly, I mean that would be could be an argument.
Yes. So I entirely agree that the annual service charge is the first 5 lines of clause 5.2. Right. These are merely examples.
Yeah.
The example. So what you're asking yourself contractually is this a cost that was incurred directly or indirectly in connection with the management or maintenance of the estate? If yes, you pass 5.2. In helping you to answer that question, the lease has given you examples. And the example it's giving you here, with the last 4 lines of D, is that within the scope of those broad words at the beginning of this, includes your own internal staff costs, their salaries, anything else you pay to them, and an element of profit. So what it's showing is the breadth, I suggest, of what is the annual service charge.
That's inevitably going to involve some element of estimation.
Quite.
Because you don't have individuals who are exclusively tasked.
Quite.
And you can simply enumerate them and say that was him or her.
Absolutely. In a moment, we'll just go back and we'll look at the examples, because some of them don't require estimation. Some do, and some, the reserve fund, are a sort of structured estimation. And then the final example under E is I simplify enormously, but it's essentially the costs of external professionals such as surveyors. So if you've had to bring in an architect or a surveyor in connection with the management or maintenance of the building, e.g. a major repairs project, you could have the costs under 5.2 by virtue of this example that's given there. You then have the final item that goes into the annual service charge, which is sub 3 at the bottom of that page, which is the reserve fund, which is such amount as the landlord or its surveyor reasonably considers to be desirable for such other matters not mentioned, so long as they're of a short-term cyclical nature and not regularly recurrent.
Contingent fund.
Yes, exactly. So that one is what I've termed in my note effectively a structured discretion fund, because your surveyor has to do it, or you're identifying what hasn't been covered, what's likely to occur, what's not going to be cyclical. So what you're doing when you're creating this pot of money called the annual service charge that's going to have to be allocated, you're asking yourself, does this cost, has it been expended or provided directly or indirectly in connection with the management or maintenance of the building? You take these 5 examples, and in the case of, say, A, you're probably just adding up invoices, because the repairs you'll have the invoice costs for. In the case of D, for example, there is, as my lord said, an element of judgment here, because you'll have to work out how much of the staff time relates to this development, how much of the profit element to include. And then with 3, the reserve fund, you're doing a structured analysis as to what's going to fall within this cyclical reserve fund over the next few years. And that will give you a total figure, and that figure is the annual service charge. So let's say...
So what is an example of something that's short-term cyclical but not regularly recurrent?
Short-term cyclical but not regularly recurrent.
Flooding. Could be flooding.
Yes.
I mean, it doesn't always happen. Doesn't happen recurrently, but it's short-term cyclical. You know.
Seems to be regularly recurrent.
Well,
Rat
Right.
infestations.
Yes, that's a very good one. Rat infestation happened on the facts of this case.
Yeah.
It could be something that you think will happen again next year, but hopefully if you've got the money there and you can treat it, it won't come back.
Right.
So you take up, you add all of those costs together, including those estimated, apportioned, structured estimated costs, and that gives you a figure, and that figure is the annual service charge. So let's call it £10,000. Let's say that's what we came to. You then go back to clause 5.1. And what they have to pay to me is a proportionate part of that annual service charge, i.e. of the £10,000 total. So
it's across the entire estate. £10,000 is a little bit. I mean, let's be a little bit more realistic. It's not going to be £10,000, is it?
Let's call it £1 million then.
Okay. Let's just to be very clear what we're talking about, because it's going to be a significant sum of money across an estate of this size.
Yes, it will be.
Hopefully not 1 million, but it could be.
Let's call it 100,000.
Yep.
Make it probably a realistic figure. So you're asking yourself, what amount of the 100,000 is the proportionate part? Suppose we conclude that £5,000 of the 100,000 is the proportionate part. And we reach that by saying that for all of the repairs, let's say, we're apportioning those costs equally, 1/138th, because everyone benefits the same, or cutting the communal grass probably easiest.
What does proportionate actually mean, you say? Proportionate to what?
Well, can I finish this and then come back to that point? So you take your annual service charge figure, the £100,000. Now we have to identify the proportionate part first because we're making the demand.
Yeah.
The proportionate part is the proportionate part of the 100,000. It doesn't mean that we have to charge the same proportionate part for each item within the 10,000. This is about the outcome allocation of that 10,000 for the 100,000, sorry. So if we've incurred 100,000 and we think your proportionate part is £5,000 of that, of which 4,800 is repairs split equally, and £200 is management, as long as the outcome, £5,000, is a proportionate part, we've complied.
Yeah, but okay, you're begging the question of what proportionate means. I mean, it may well be that different items, whether falling within the 5 categories or not, might be arguably attributable to different lessees in a different way.
Yes.
So proportionate could be done on a granular level. I mean, as well as collectively. I mean, I understand the concept of it's the collective annual service charge, but it's why I go back to ask you what is meant by proportionate. What do you mean? You know, what does the lease mean to the objective bystander when it says proportionate? Proportionate to what? Proportionate to whom?
Well, it means, this isn't to duck the question, but to go back to the wording. You start with identifying your annual service charge,
Yeah.
and you ask yourself then, well, how much of that should go to this property
Yeah.
to represent the proportionate part?
Okay, what's the frame of reference? I mean,
Yes.
we could use the word fair, but it wouldn't assist the.
Well, the next 2 leases is a fair proportion.
Yes.
Yeah. So what's your frame of reference?
So the frame of reference for grappling with that is the landlord's assessment, because it's the landlord who makes the demand.
No, that's just who does it. What frame of reference does the landlord use to allocate the charges? Now we know that some houses on the estate have to have a pure arithmetical 1/137th. So they're out of the picture, are they? When you're deciding proportionate part, is it only proportionate between the remaining leases that have this wording?
No, it's the starting point is always the annual service charge.
Yeah, okay.
But this isn't to be difficult, and this isn't trying to duck your question. It's not identifying it by reference to anybody else on the estate. It identifies it by reference to a crystallised sum.
Yes, but why isn't it doing so? Because the annual service charge as defined, we've seen, is the total charge across all buildings on the estate, including those that have to be charged a 1/137th arithmetical part. So it's for the whole estate. So what is the frame of reference to determine what is either A, proportionate, or B, fair? For any particular tenant.
So I would suggest that the touchstone here is likely to be, firstly, what benefit do they receive? Which isn't necessarily judged from their perspective, because they may not see the benefit to cutting back the bank on the far side of the river.
So objective benefit.
Yes. But if we don't cut the bank back, there'll be a rat infestation, and eventually it will get to them. So objective benefit, and then value for money.
But can I put an alternative proposition to you, which, whether it's fair or proportionate, and perhaps it's more clearly suggested by the word proportionate, would you not at least start from an assumption that the annual service charge would be divided equally between all properties on the estate? And if you were to, and you could depart from that, but you would have to justify it.
No, because if that's...
Why is not at least a starting point to say that proportionate means equally, or fair means equally? That equality is equity. Why don't you at least start from that proposition?
For two reasons. The first is, if that is how the draftsman wanted to do this, a different form of wording would have been used. You would have said expressly, it is 1/137th and 1/138th.
No, you wouldn't.
Or such other proportion as the landlord acting reasonably may determine. That's how you'd have your that's how you'd create a contractual discretion of contractual arrangement.
But isn't that what proportionate or fair might actually mean?
No. So my first answer was, I say you'd write that, to create my lord scenario, you'd use different words.
That's the first reason.
Yeah. The second reason is proportionate or fair don't necessarily mean equal.
I understand they don't. I didn't suggest they necessarily meant equal. I just said that would be a starting point without some justification.
But the starting point, respectfully, is to go to the word itself, not to potential synonyms.
No, but okay, let's take the word fair. Very, very frequently in common parlance, people understand the word fair to mean equal. You know, the child said, it's not fair my sister's got that, I haven't. What they're really saying is we should both have it or have half each.
Or mostly they're saying I should have it.
Well, they might. Okay.
In my experience.
Yeah, okay.
But look, I mean, can I just cut through some of this by asking this? I mean, presumably your estate, in this instance, and probably in other instances, doesn't consist of identical buildings. That there are buildings of, I mean, are we talking about buildings that have, I mean, some are on the upper floor, some are on the lower floor, maybe some are larger than others, and some are smaller than others, I don't know. Is that so?
Inevitably, yes. Some are houses, some are flats.
Yes, exactly. So, I mean, people aren't going to be able to get around a service charge on the basis that they have different square footages, or that somebody has a nice south-facing garden and I'm facing block of ivy or whatever it is. The idea that equality, I mean, I'm throwing this out in a sense in support of your submission, but I'm not advocating it. I'm just seeing where it goes. You can't have equality between things that aren't equal. As a starting point, there will be more or less desirable properties on the estate, but because of their size and situation, no doubt.
That is certainly, I think, part of an answer that I would gratefully adopt. You are obviously right that there will be differences between the buildings. There.
I mean, do they have different numbers of bedrooms, for example? I mean, presumably you've got places for families and you've got places for singles.
Quite, and I wonder if my Lord's thinking of these because you'll be aware that bedroom weighting is actually a fairly common methodology in some.
But I don't think there's anything between what my Lord has just put to you and what I put to you. It's just that my Lord has stepped in at stage 2 because he's saying surely there are different buildings, and I'd be saying yes, and that may be a good justification to depart from your starting point. You've got to start somewhere. You've got to start somewhere, and isn't the starting point when you say either fair or proportionate to say equal? And if you're going to depart, whether it's because the buildings are different or otherwise, you've got to give some reason for it, some justification.
Well,
I mean, if you had an estate consisting of 138 identical houses, but half were painted with a red front door and half were painted with a blue front door, how would you divide up? So, absolutely identical tenures, identical houses, no difference between them whatsoever apart from the colour of the front door. How do you apply that?
So the answer to that, and I hope my Lord doesn't think I'm being cheeky when I answer this, is it would actually depend what kind of landlord I was. If I were a private sector landlord, I would go to the RICS code, and that tells me that if I have absolute discretion, I should apportion according to use and availability. That would be my starting point. If I were a social landlord, I would go to the applicable social codes and see what I'm supposed to do there. I take the point my Lord is making.
I'm just saying that, well, first of all, when this lease was drafted, I'm not sure the codes were in either the same or indeed any form, but surely you, just as a matter of contract, would say, if I have absolutely identical houses, save for the colour of the front door, I would have to apportion this equally. And the reason for that is because an attempt to differentiate on the basis of the colour of the front door bears no relation to what the purpose of the service charge is.
So my Lord, I don't dissent from that. But I do say respectfully, my Lord's asking the wrong question. That's the analysis we get to on the assumption of a remitted matter. At the moment, it's clear. On this appeal, the only issue I'm trying to succeed on is whether, in principle, we can deviate from a straight 1/138 split.
And equal. And I'm simply asking you, given that your proposition is that the critical words in this appeal are proportionate and fair, that's what this appeal turns on. I'm asking you just to explain what they mean. Don't get me wrong. I think it's actually a very difficult question because in a lot of other areas of law, the word fair or proportionate or equitable or just are bandied around without a frame of reference. And the problem is then everybody is left scratching their heads to think, what's the frame of reference? You want to give some content to those words, so I think I'm entitled to ask you, what's your frame of reference?
My Lord is always entitled to ask the.
Okay, well, sorry, that's true, but I mean, I'm just trying to tease out why you say those two words justify or give you the flexibility to depart from equality, i.e., an arithmetical equal division of the whole.
So the answer to that is because a straight line 1/138 for all items for all time is not and could never be proportionate for every single item of expenditure.
Yeah, but that's just answering the question using the same word that you need to give some content to.
But it is the critical question.
So why is that?
Because on this appeal, all I need to succeed on is to show that Judge Cook was wrong to say that I am constrained to always use 1/138.
I'm not sure you. I mean, I think that's a bit artificial. But what my lord is asking for is an explanation of why you succeed. Because we're not simply going to say, well, we happen to agree with the appellant, but we're not going to tell you why. We would have to give reasons, and those reasons would feed into what was being remitted and how that remitter was to be dealt with. And so it's for that reason that we need to understand if Judge Cook was wrong, what she should have said.
So what Judge Cook should have said is that you start with a crystallised sum of money called the annual service charge.
A big pot.
Big pot, yeah. That pot must then be divided.
Correct.
This person must pay a proportionate part of that.
Or a fair part.
Or a fair part in the other two leases, yes.
I'm not sure. I'm just to check. I think the alternatives are fair proportionate.
Fair proportion, yes.
Fair proportion, as it were. I think proportionality is a constant theme in these three leases, but two of them have fair proportion.
Yes.
And speaking for myself, I'm sure that when something says it should be proportionate, it actually means it should be a fair proportionate part. But so I don't know whether there's likely to be any difference of opinion about that. But so whether it's fair proportionate or proportionate, we mean the same thing.
Yes, I agree with that. So what you're doing, the process you go through to produce the amount of money that has to be paid, is the landlord identifies the totality of the cost, the annual service charge. The landlord then forms their view as to what amount of that is the fair proportion or the proportionate part. That doesn't mean that each individual stream has to be charged the same thing.
I totally get that, but you're still not, with respect, you're just ducking the question. How does the landlord assess what is a fair proportion of the whole?
Well, on the facts of this case, you can see how the landlord did it. It took the view that for repairs, it would split them equally. Now, and the reason for that being twofold. One, everyone derives benefit from the estate being well maintained. Secondly, when you look at the first clause 5.2a, it's talking about the entirety of the estate. So the draftsman is looking at treating the whole thing as a whole. Oh. On management, because it isn't as simple as a time and motion survey about what you did, about how many hours each officer spent on this development, because there is, as my lord said, an element of estimation looking at how our staff are deployed, it decided that a proportionate part was £300 for this one. And it explained that by reference to the types of tasks that managers were carrying out. Now, at the risk of prompting a scolding, I do say that is where Judge Cook went wrong, because Judge Cook says I can't do that. Judge Cook says you get the entirety of your pot and you split it equally. She denies any flexibility in this concept of proportionate part. And she also, in my submission, applies what her fixed proportionate part to each of the streams. If she's wrong about that, and we do have more flexibility, whether or not in fact we can justify a particular charge is the remitted question. And I'm really not trying to be difficult.
No. I mean, you see, the way I would approach this at the moment is that, and obviously we haven't had an argument at all, but you see, as soon as you start talking about proportionality or fair proportionality, you just need a frame of reference. And everybody knows that this lease is dealing with buildings as defined, which encompasses the whole estate of a load of leases, load of devices. And your, in a sense, I say at the moment, I'd say your starting point is equality, is fair or proportionate, and all you need to do to move from it is to have a good reason or an appropriate justification. Now, what that might be will be tested, by whoever's arbitrating the lease. And so, you see, if you say yes, we have that flexibility, that Judge Cook was wrong to say you didn't, understand that, but you do need to actually give some content to the flexibility, so that the objective bystander at the start of this lease, just looking at it, would say, okay, how's this going to work? And one way as it would work is that the objective bystander looking at this lease would say, you start from an assumption which may be your ending point, that you share the annual service charge equally between the properties that comprise the buildings. But if there is a departure from that, the landlord has to justify it. What's wrong with that analysis?
So I can answer that, and I will actually answer it. One is, there's nothing wrong with that from the narrow perspective of my client on this appeal. Because for the appeal to be allowed, which is what we're seeking here, we just need there to be recognition that Judge Cook was wrong to say there's no flexibility.
Yeah.
Now,
I understand that narrow forensic point, but you will end up with a judgment. So one might as well grapple with what, once you accept that the starting point is fairness, and then there's some reason for departing on it in an individual case. You would say appeal allowed, but you're likely to end up with a judgment that at least grapples with what those reasons might be.
I understand. I can read the runes even if not.
No, can I try something slightly different? I mean, I sense that you're reluctant to fall in with my Lord's suggestion of an equality starting point, possibly because the properties that are involved in this equation are not equal, and that therefore equality might not equate to fairness. Is there any difficulty with an arithmetically equal division being a point of reference as opposed to a starting point? I mean, if one was considering, anybody considering what is my service charge here and wanted to go into it, will want to know what actually, if I was simply being charged 1/138th, I would happen to be paying. That's a relevant matter. Would be, no doubt, common sense to think of that. But the proposition that was being put to you was the starting point from which you have to justify a departure. So, you're not happy with that.
Well, let me explain why. The reason why I'm reluctant to accept that. I am not here, as made clear, because my client is concerned about these three leases.
No,
it's the other 1,000.
Yes.
And I'm very conscious of two factors. One is that I, and indeed no one else in this case, manages property for a living. And so I am very reluctant to tie my client down to a position which might cause chaos on another development.
What you do for a living is to interpret documents.
Yes.
And so, and it's precisely for the reason you've just given that these leases have broader application that I'm trying to tease out from you what these words in this lease mean.
So these words in this lease mean that we can apportion that annual service charge in the way that we consider proportionate or fair. What that means in any individual case depends on the facts of that individual case, because we might take different views about what is proportionate and fair within a service charge. So as to the items we charge to one dwelling, within an estate, and certainly within our stock.
It's not. It cannot be an unfettered discretion to be exercised by you. It cannot be which particular palm tree you sit under from day to day. There has to be some metric by reference to which your decision can be tested.
I would accept that, and the tribunal will grapple with whether what we have done is proportionate.
So what do we tell the tribunal in the judgment, if you're right, they should be using as the frame of reference?
They should be looking at the reasons that were given by the landlord for this apportionment of this charge on this estate. And it should be judging those reasons against the wealth of case law that tells it that effectively it's exercising a review function akin to judicial review of our decision making. It's not deciding for itself what it would do. It will be asking itself, have we reached a decision within the range of reasonable decisions open to a properly informed landlord? That's how this works.
Can I just, on that specific point, if you look at the proportionate part, on page 41, it says annually a proportionate part. That actually, it doesn't say what the landlord considers a proportionate part.
No.
Which is different wording from what you are suggesting. I well understand that in reality you're the person making the decision, and then we'll be explaining why it's proportionate. But I would be very reluctant to interpret words by inserting what the landlord considers to be proportionate.
Well, I perhaps let me do it this way. You're obviously right as a matter of construction, that's not what it says, but you're also obviously right as a matter of practice, what has to happen. Someone has to form a view. It can only be us, because we're the only ones who know what the annual service charge is. We keep straying, and I do understand why, and I appreciate the patience that's being shown as to my reluctance to engage with it, but we are straying in my submission beyond the four corners of the appeal. I appreciate the point that's being put. I appreciate the point about guidance to the first-tier tribunal. I see the value of that, not just on this case, but because my client is here for broader stock management reasons.
I'm sorry to interrupt you a second. It does go further. Unless you can provide a workable meaning to the words fair proportion, which is other than just an arithmetically equal part, you may not succeed in showing that you have the flexibility to do anything other than an arithmetically equal part. You have to show that there is something workable that an objective bystander looking at this lease would understand those words to mean.
I'm not sure with respect I do have to do that, because once one accepts, which I think probably is accepted, at least into testing it in the argument, that proportionate doesn't necessarily mean equal, that's enough to allow the appeal. I do appreciate what's being said, I really do. And I do appreciate that intellectually, I see an awful lot of attraction in the way my lord puts it to me. We have to have a workable clause. How is the clause workable? Start from equal split, but you can deviate from that if what you're doing is achieving a proportionate or fair split. Because equal may not always be fair, and equal may not always be proportionate.
Correct.
If that's the conclusion that is reached, and I'm happy with it, I can adopt that as reasoning. But I do say that's not the question on the appeal. The question on the appeal is narrower. It is, does it only mean equal split? Because that's what Judge Cook decided. She says no discretion at all. And if she's wrong about that, which in my submission as a matter of language she must be, that's enough to allow the appeal.
Except, as my Lord Justice Dingemans put to you, it's not very satisfactory to just say, Judge Cook was wrong, it doesn't always mean equal, but we're just not going to tell you what it does mean. It's a matter of interpretation. We're here to interpret the contract. We're here to give a meaning to these words. And it's really of no help to man the beast to simply say, whatever it is, it's not what Judge Cook said.
Well, it wouldn't quite be as simple as that. It would be, it's not, it doesn't mean fixed. It means proportionate. And what you do, the bit we skipped over this slightly, but you have to look potentially each year what is proportionate could change, because you pay to the lessor annually a proportionate part. It's quite possible that what is a proportionate part changes both within line items from year to year, but also outcome-wise from year to year.
Yep.
And that is why, in my submission, the answer is to say, Judge Cook was wrong. It means proportionate. In some cases, equal may be proportionate. In other cases, it won't. It all depends on the facts and the reasoning put forward by the landlord.
Can I just,
My lord, yes.
as you've talked about Judge Cook's reasoning, take you to paragraph 20 of her judgment in the last sentence, and perhaps we can make some progress or not in relation to this, where she says there's no basis on which the lessor can charge a flat rate for item D that's determined by the tenure of the property. So why would you say it was proportionate to work out your service charge by reference to tenure?
The tiering system is the product of Accent's review of the time that it spends dealing with each kind of property. And you can see that when you look at the tiers, because the most expensive tier is supported or sheltered housing, and the least expensive tier is standalone property with no or minimal estate. So the tiering system reflects what I would suggest you'd expect to see. A landlord's assessment of the proper allocation of its employees' time across the entirety of its stock, which is what the tiering system is perfectly capable of being proportionate
So could you just repeat that? The landlord's assessment of
the proportion of its employees' time that is spent dealing with different descriptions of property within its stock. Is capable of giving rise to a proportionate allocation of those costs.
Well, it will necessarily give rise to a proportionate allocation. The question of whether, and if so, by reference to what metric or framework, it is a fair proportion.
But that becomes then the next question about each. Then you're looking at individual challenges to individual service charges. And that's what doesn't arise in this appeal.
Okay, well, we're going around in circles then.
I appreciate A, that that argument probably isn't finding favour, and B, I do appreciate the broader point that's being put about the need to give further guidance. I simply,
I mean, some time ago, you gave something of an answer to the question that we're grappling with, which is that you said there are two touchstones. One was benefit, honoured, seen objectively, and the other was value.
yes.
And I mean, we haven't particularly approached this, but it's arguable, possibly, that if you compare somebody who's on an assured tenancy and somebody who's on a long leasehold, that they both have They both share, in a sense, the value of a service charge in the sense that it protects their daily occupation of a property. But a service charge also protects the value of the asset of those who are on a long leasehold, where those who are not on a long leasehold do not have an asset. And so is that the sort of matter that is going to be argued as justifying a differential in terms of tiering? Because on the face of it, it's not apparent to an outsider to this area why it doesn't in fact involve more work on your part with assured tenants who may be coming and going more than one would have with long leaseholders who may be in a more lengthy or stable situation. Is the difference in tiering likely to be justified under value rather than benefit?
This is the difficulty with approaching the individual justification when I lost on principle. It depends is the answer. I don't know, because this wasn't explored below, precisely how we would want to try and answer that question. I think I have an idea based upon just doing this kind of work, but the difficulty with giving that answer is I don't want to be giving evidence here. I strongly suspect, if we were asked, part of what we would explain is that when you're dealing with assured tenants, one of the things you've got to be very careful about is the housing benefit rules. And you've got to make sure that any charge you levy is going to be payable by housing benefit. Because there's no point creating a charging system that your occupiers can't meet.
But that may be...
And then that impacts upon whether you call something a management charge or whether you put in the rent or whatever it's going to be.
Factors like that, you see, a tenant may say, who is not a socially housed tenant, but who is subject to one of these leases, they may say, that's got nothing to do with the benefit or the purpose for which an annual service charge is levied. That's just you, as a landlord, looking at your own operations and a cost-benefit analysis for internally, and it has nothing to do with the contractual purpose for which an annual service charge is levied under this lease. Now, so that's why I'm trying to identify the frame of reference, because to make this contract work, you need to understand how you determine what's fair or fair proportion, and there needs to be the frame of reference. And at the moment, if you are right on your first and narrow point that Judge Cook was wrong to say it's always fixed at just an arithmetical 1/37. The question of fairness or proportionality should, I would suspect, be determined by reference to the purposes for which a service charge is levied as understood by the lease. And other factors, if that's what's justifying your flat £300, may actually fall outside the remit of the lease.
So and this is why I was very careful, I hope, to make clear that that's an answer based in part on my own speculation.
Absolutely.
rather than what the client...
But it's a good illustration of why we do need to grapple with the concept of not just whether Judge Cook was wrong, but actually what does this mean?
Yeah. I, at the risk of repeating myself respectfully, no. The question on the appeal is, was she wrong to say that it's always fixed? If she was wrong to say that, then the detailed thought process, justification, methodology is the thing the learner friend wants to attack in the respondent's notice. And that's what goes back for decision on the facts of this case. I mean, I'm slightly reluctant to get into this because this is all material that was produced after the FTT hearing. But as my learner friend flagged, one of the leases hasn't been appealed because it's a straight must use 1/137. So we've had to work out what is 1/137. And if you go in the supplemental bundle to page 163, we've started doing that for the 137 lease.
So 137, did you say?
Sorry. In the supplemental bundle, it's at page 163.
163, sorry.
So this is a document that isn't produced in this appeal.
This is the FTT remitted
This exactly
from the Upper Tribunal. Yeah.
Exactly. So the one lease where we aren't appealing, that's got to go back to work out what the 137th is, and directions have been given for us to do the very process that we're grappling with now.
Right, it's 326, is it? Page 169. Is the figure you come up with on that?
Yes, but the starting point, to pick up on my Lord's question, is at page 165, general principles for calculating the management fee. So what we've tried to do is identify the costs associated with the leasehold team in supervising and managing the services at this development, and then their administrative support. Look at 4.1. Then we've broken it down. Direct and indirect costs. We've tried to work out what the overheads are. We've explained what we haven't taken into account at item 10. On page 169, as my Lord said, we actually think if you do this on a closer to a time and motion basis, we think we spend £326.20 managing this property. So that, when this goes back, that's how we'll try and defend the 300 figure. We'll say, look, it's actually less than we incur, albeit we can only charge you 1 over 138 of it. But this is the reason why I'm so reluctant to get into this, because one, that isn't evidence in this appeal. And I show it to you because I can't think of any other way to try and make the point. But secondly, that's what we'll have to do. This is the kind of analysis we will have to do back in the FTT to show you why we think this is proportionate. At the moment, we don't get to that analysis because Judge Cook has said we can't do this.
So at what stage is the fourth property got to?
It's in the, I think it's stayed in the FTT. We're awaiting the outcome of this because, as my friend indicated earlier, if the appeal succeeds here, there's obvious good sense to having this one kicked back to deal with the other lease.
Right, and also we've got to bear in mind, presumably, that the charges that we're being argued about here were 2017 and so forth charges, and this is a 2022 calculation.
Quite, yes. And it may well be said as well, there's an element of after the event justification, and there'll be questions about interest and inflation.
Yes.
And it may not be that any of this is agreed. This hasn't been tested evidence yet at all. But it's because that's what I'm going to have to do to answer all of the points my Lord is making. Because that's what we've done for the other one. And it may be that some of those items a tribunal says that's irrelevant. That shouldn't be in there it's not a relevant factor.
So really, does your argument boil down to this, that you accept that that there are issues beyond simply appeal allowed, but that if there is to be an in-depth challenge to the precise way in which Clause 5 ought to operate in these leases, it's a matter which may have to be dealt with on another day.
Yes.
Once the exercise has been done.
Quite, yes, because as my Lord keeps pushing me on, and I was like, I accept, but it's just a question of venue. What we do is important. I don't pretend we can just say, well, that's the figure, we choose it. Of course we have to explain, but it's when and where. At the moment, I don't get to that stage.
I mean, I am slightly surprised why. I mean, maybe it's just the vigour of the exchange we've been having. You think that the point I'm putting to you is perhaps a more hostile point than it is. But the difficulty I see is that if we follow your analysis, somebody in the FTT is going to have to decide whether the number which you charge to a particular tenant is a fair proportion of the pot, the whole. They can't do it just by an arithmetic exercise as this one that we've just been looking at does. I mean, the question of what's in the pot is open to challenge, understand that. But once you've got the pot, that's what we're really looking at. The FTT is going to say, okay, so how do we decide whether having defined the pot appropriately, this was a fair proportion of it to allocate to this particular tenant? And it seems to me that unless we say, well, why don't we just let them sort out what a fair proportion is, they can take a view as to what that means in the contract, and we'll just have another appeal if the parties don't agree on it. The alternative is that we grapple now with the meaning of the clause, so that the FTT isn't left scratching its head as to what or how it goes about the task. And it seems at the moment to me that the flip side to saying, as you would have us do, that Judge Cook is wrong, is to actually give the correct answer, not just to say she's wrong, but we're not telling you what the correct answer is. And I'm suggesting something which I thought, I'm slightly surprised to see it met with such hostility, but I don't mean that in an unpleasant way, but pushback, that it's simply a question of you must provide a justification which meets with the purposes for which a landlord can levy a service charge on a tenant. And if you provide a justification which is, to use your word a little bit earlier, genuine and rational, then that fits with the contractual framework. If you choose a justification which has nothing to do with the purposes for which you're entitled to levy a service charge, because it discriminates between people who have red doors and blue doors, or because it just is better for your economics of running the business, then you may fail contractually. But if you come up with a justification which makes some sort of sense from a landlord and tenant's point of view, you'll win. But you've got to come up with a justification.
So, I certainly didn't. I hope it didn't come across as a hostile exchange. I understand the point.
I made it clear it wasn't. It
No,
was
quite.
a vigorous exchange, but it was
full and frank exchange of views. Testing of arguments. My starting point is that the answer, appeal allowed, Judge Cook is wrong. It is possible, in appropriate cases, to have different allocations of the items in the pot. It is all I'm seeking. Because that's enough to give me back the flexibility that I've lost. And it's the flexibility I'm primarily concerned with. If the court takes the view that that's a hostage to fortune, and all we're doing then is inviting open-ended litigation in the tribunal about what is and isn't a relevant factor to take into account, I don't necessarily disagree with the way you just put it, my lord, that so long as we can explain it and so long as it falls within four corners rationality, that's enough. But I don't need to go that far on the appeal. And the reason I ask you not to is that it's A, on the facts of the appeal, what we did and why hasn't been tested yet. But B, on the broader reason for our pursuing this appeal, our stock management functions, the range of scenarios across 1,000-odd properties isn't something we can usefully foresee. And that's why we seek flexibility with individual cases to be worked out.
I think we've probably got everything we need in relation to this, but there appears to be at least a modicum of common ground, which is that the service charge has got to be justified.
Yes.
In terms of clause 5.
Absolutely.
Right. Now, have we any more to look at then for the purpose of your appeal. You'll obviously have a right of reply when.
Not from me. Can I just briefly turn my back and
Certainly.
see if there's anything else to deal with? No, my lords, thank you very much.
Thank you very much, Mr. Bates. Yes, now, Mr. Fine, we all started the day with great ambitions to be finished by certain times, and so but that simply doesn't apply. You have all the time you need.
I'm grateful, my lord. As my learned friend has observed, this is really primarily an appeal which deals with a matter of construction. I'm perhaps in the slightly enviable position compared to him, but I have a simple answer for this. It's going to be my submission, but that the manner in which the lease which is unappealed is highly relevant to the manner in which that's going to be dealt with is highly relevant to the other leases, for reasons which I'm going to enlarge, and that we have a fairly straightforward and simple calculation to go. In other words, to headline it, the annual service charge is a fixed lump sum. What my learned friend is trying to seek to direct you towards is by going down into that, looking at streams, which is the way that he puts it in the skeleton argument, and saying that proportionality or fairness can be applied to particular streams in particular ways. And in my submission, that is simply not a realistic or an appropriate construction of the lease that we have, which is essentially in common form over the total of the annual service charge, and that proportionality and fairness reflects a mathematical approach which is taken on the lease which isn't appealed, 137th. That's a fraction. A fraction is a proportion. It applies therefore to the second lease, the one that we've looked at most closely now. Grateful to my learned friend for using that lease, because when I prepared all my notes, I use that lease as well. It's the first one in time. But equally, when we talk about a fair proportion, we're dealing with something very similar. And I say also that that reflects what the First Tier Tribunal found, which was that there was a long-standing agreement in relation to that fraction, and it accords with common sense and a reasonable, what a reasonable objective person would understand.
Your core proposition is that the annual service charge proportionate share is an equal fraction.
That is undoubtedly the starting point, but what the learning friend is asking you to find is not, it goes beyond saying that it's a fraction or an adjusted fraction, because we've already got from 137th to 138th.
Yeah.
What he's trying to say is that not only do you have a fraction at that point, but you can then break up the
Yes,
actual
I understand.
element.
I'm just seeking to just make sure I've fully identified your core proposition,
Yes.
which is, as I understand it, that it is in fact an equal fraction,
Yes.
the service charge.
Yes.
That's right, isn't it?
Yes. Now, if you disagree with me,
I mean, you made another point, as it were, clearing your throat, which was that you're going to show us why lease 4 is highly relevant
Yes.
to leases 1 to 3. But in the end, what you're standing for is a suggestion that proportionate means equal fraction.
well, proportionate means a fraction. Yes. If you're against me on it being an equal fraction,
No,
then
no,
it
I'm
might
not
be an
against,
adjusted fraction.
not against you at all about that.
No.
I mean, I just want, it's useful to us having to completely clear our minds of the submissions we just heard for a moment and consider exactly what it is that your case is. And I want to be.
It's a fraction of the whole.
But
It's a fraction of the
It's a fraction calculated by
annual
reference,
service charge.
by reference to the number of properties, and it's the whole estate divided by the number of properties on it.
Yes, that's my primary position. My secondary position would be that if it's not a straightforward fraction divided by 1/137
Yes.
or 1/138, then you might have some adjustment whereby, for example, if two properties were merged into one, so let's say a house was knocked through, so we've got a 6-bedroom house, then that might be 2 138s rather than 1 138.
Well,
So
that's really just a sort of avoidance provision.
well,
You can't get away with that by simply knocking through.
maybe so, but I think what I'm saying is that fundamentally it all works the same way. And what I'm absolutely saying is wrong in my submission is that you can look at the annual service charge and look at the component elements and then apportion those differently. That is not what the leases allow, and in my submission, that is not what is meant by proportionate or fair and proportionate, which goes to the fraction approach.
Well, you just say, as I understand it, you say you put together a pot for the estate as a whole.
Yes.
In fact, it's not pot, actually, we talk about a pot. It's actually a negative pot.
Yes.
You put together the expenditure for the estate as a whole.
Yes.
And you say that whether it's fair proportion or proportionate, it just means equal.
Well,
equally divided between the properties, subject to some possibility of somebody buying 2 properties and knocking them into one or whatever. But,
yes.
but basically,
subject to minor adjustment.
Fairness and proportionality means proportionate to that this property, subject to this lease, bears to all the properties
Yes.
on the comprising the buildings as defined, and that's what anybody looking at the word fair proportion or proportionate within this lease would understand.
That's right.
And just
But I do think it's important to go beyond that and say that under no circumstances, I say, does a lease stand the analysis of a learning friend applies to it, and that is that you can just take a given stream and apply a different figure for a house for that stream than for a 1-bedroom flat or 2-bedroom flat. So in other words, that aggregate, the total liability for annual service charge, which has to be divided up, is itself not capable of that sort of breakdown or analysis. And that's fundamentally where my learning friend is going with this.
Yeah. Just pausing before we get further. On what basis does the interpretation of this lease that we've been looking at, or indeed the following lease,
Yes.
Why, as a matter of interpretation of the contract, are you allowed to look at another lease between a different person, between different people? I mean, there's no. What evidence is there that the signatories, for example, or the assignees of the lease at tab 3 or tab 4
Yes.
would have known the terms of the lease in tab 2? I mean, that's a fairly, why would you wouldn't know, would you?
Because the leases say so.
What?
Because the lease is signed at the tabs that you have taken me to.
Well, let's we've been dealing with the one at tab 3.
Well, let's just deal with it chronologically. But in fact, what I'm about to say appears in all 4 leases.
Okay. So you're not, in fact, going to make the submission, which I misunderstood you perhaps to be flagging, that the signatories to the lease at tab 3 that we've been looking at would know that in an earlier lease, the one at tab 2, there was an arithmetical fraction.
What they would know is that all the leases which were going to be granted on this estate were going to be, I'll look for the precise phrase. So this is what is said in all of these leases. It's by way of recital. It is the intention of the lessor, and the lessor is common to all of these leases, to demise the flats comprised in the buildings upon terms similar to those herein contained. That's what it says every time. So that recital appears. We'll start with number 2, tab 2, because that's the earliest in time. Bear in mind, this estate was then held in the name of Bradford and Northern Housing Association, and it presumably was a somewhat smaller outfit than Accent. I believe that Accent is a composite of various housing associations. And we have so page 2, you have the general description. This is the lease granted to Noreen Mooney. We then have the recitals about the stated to be simple, the first one, about the charge to the Housing Corporation, that the lease, the third one is made pursuant to the right to buy provisions of the Housing Act 1980 as they were then, that there is a discount of £651.48. In the lease, following expressions will have following meanings, and we've already touched upon that. The definition of buildings, flat, the flats, the owner, and then 6, it is the intention of the lessor to demise the flats comprising the buildings upon terms similar to those contained herein.
Yeah, but so that rather makes my point. Somebody signing the earlier lease, which includes the arithmetical division, would think that everybody else on the estate would have a similar arithmetical division. But somebody signing the lease in tab 3, containing the same provision at page 29, wouldn't think that everybody else on the estate had a lease that said 101, 137. They would think that everybody on the estate had a lease which referred to a proportionate.
And what I'm saying that arises out of that is that that demonstrates the intention in the formation of these leases that everybody should be treated similarly. And therefore, if you have the earliest ones, as we have here, the earliest one, having a mathematical proportion, then as a matter of construction, it's hardly likely that there was ever an intention to significantly depart from that.
Well, as a matter of interpretation of the original lease, I agree with you. Because it would be said that if there is something materially different, it's a breach of the contract, breach of the lease with the first lessee. But it doesn't enable you to interpret the subsequent leases, which is what we're actually engaged on, because they are told everybody on the estate, in fact everybody in the estate from here, but everybody on the estate has leases that talk about a fair proportion or a proportionate part. So it doesn't really help you at all to determine what fair proportion or proportionate part means.
Well, in my submission, it does help in this sense that the approach that my learned friend is adopting is one that has the effect that there is a significant difference between the way that the later leases and the earlier leases operate. What we know, what is part of the factual matrix in relation to the grant of these leases, is a statement made by the lessor in relation to each of these leases that they should all have a common effect. Not be precisely the same, but have no significant departure from one lease from another. That there would be, and this is what Mrs. Yeadon, presumably, or Miss Yeadon, when she had the first of the leases under consideration granted to her, that her position would not be materially different from that of the other people who had right to buy leases on the same estate. And what I say is that is a matter to be taken into account, because that was the stated common intention of the parties in relation to each of these leases when it was executed. And the consequence of the approach, my lord, that you're suggesting is that the lessor could render that recital nugatory, because the lessor could at different times behave in
the lessor may have
ways.
Breached the contract with the lessee at tab 2 if they've in fact entered into leases which have materially different operation. But it doesn't mean that you interpret the lease at tab 3 by reference to an earlier lease of which they had no knowledge.
Well, two things arise from that. The first is the inherent improbability of the landlord intending to be in breach of its already entered into contractual arrangements. Only about 18 months before, between these two particular leases, think one is October 87, the other is June 89. So there is a difficulty in relation to that. I didn't.
But I mean, let's just test it a slightly different way. You've got let's assume that we're objective bystanders on the 10th of July 1989 between the Bradford and Northing Housing Association and Helen Pamela Veacock. And we tap them on the shoulder and say, just to be clear, look at subclause 6 at page 29 of the bundle. What do you think the leases of all the other houses on the estates look like? What would Mrs. Veacock say in relation to the clause 5.1?
You'd expect it to have a similar effect to any other service charge.
Yeah, so what would it say? What would all the other leases on the estate say? So far as she was concerned.
Well, she would expect it to have a similar effect. Bear in mind, we are dealing with precisely different words in relation to...
Similar effect to the lease she was actually signing, which says a proportionate part.
But she would expect... But she would...
So why should we... Why would she... How does it help us to interpret that as an objective bystander to that contractual exchange? To look at a lease which Mrs. Veacock may never have seen.
What I say is that firstly, because it informs the construction. So if you were testing the extent to which one could depart from earlier leases, then she could look at those earlier leases to see, or to give some to inform her position.
There's quite a lot of law. I mean, there's some fairly basic law on this. You look at the common intention of the parties. Sorry, you look at the presumed intention of the parties objectively on the basis of what they knew. And there's no evidence here that when Mrs. Veacock signed her lease in 1989, that she had any idea that there were other leases on the estate that actually had an arithmetical number in them. So how, as a matter of ordinary interpretation of contracts, can you possibly take that into account?
There's two approaches to that. The first one is that if she was being treated substantially differently to the way that those other leases operated, then in my submission that would identify a breach of the terms of the lease, which I think is unlikely, and therefore she should be able to call them in aid. The second one, is a point, I suppose, which this is taken from the additional pages which I've handed in. There are 2 points in relation to that. Now, I do accept that this is slightly different because we're talking about the effects of recitals in very similar leases and differently, but at 10.37, the interpretation contract, the recitals of documents may perform a different function to the operative parts of the document, but nevertheless they are part of the document itself, or at least part of the context in which the contract is made. Since the circumstances surrounding the making of the contracts may be relied on as an aid of interpretation, it follows that recitals may be similarly relied upon. Accordingly, a recital may set the background and purpose of an agreement. In order for a recital to be an aid to construction, it may be capable of being very consistently with the operative parts of the contract. Well, obviously there's no internal inconsistency between these two, but in my submission, if you're looking at a particular given estate, which is defined within the lease, and there is a recital which says that this lease will not be significantly different from other leases, then if another lease gives you some indication of what that means, then there shouldn't be a substantial departure from it. And there's only 3 payments made in relation to these leases. The capital payment for the grant of the lease and for the right to buy legislation with whatever discount the tenant may be entitled to. There's a £10 rent, which is statutory, as my learned friend has pointed out, and there is the service charge. So the only ongoing relationship between these parties, which is going to be significant financially between themselves, the financial level, is the service charge. What I say is those later leases cannot depart significantly from the operation of the lease of 137th, because that's what the parties were saying in their recital to each of these leases as they were granted.
If you were acting on behalf of, I don't even know who it is, Noreen Mooney.
Yes.
you were acting on behalf of Noreen Mooney, you'd be making a very good point if you were to submit that the way it's currently being put represents a material departure from that which Noreen Mooney was promised when she signed a lease containing the clause at page 3. Be a brilliant point, probably unanswerable. But it seems to me it's not remotely such a good point if you're acting for Helen Veacock, because at least so far as she is concerned, she was promised that the leases would be in the proportionate part wording.
Yes, but then begs the question, which has been much debated this morning, of what proportionate means.
Well, no, that's a different point.
Well, in my submission, that's not quite a different point because she would be able to substantiate what that meant by looking at how the other leases operated. Now, those leases
is there any evidence that when she signed her lease, she knew what Noreen Mooney had signed 2 years earlier?
Well, there's 2 points about that. First of all, in one sense, she did, because the undertaking, the recital, is something she might reasonably expect to be consistent across all leases.
Well, the title is the same, but the critical point, clause 5.1, is different. And if anything, she would have been very surprised to find, wouldn't she, that there'd been something different put in an earlier lease?
No, because what I'm saying is that there is no material difference between the approach. The annual service charge is essentially indistinguishable between any of these leases. So the aggregate is there, and she's being told that she's going to be paying a proportionate part. Well, 137th is a proportionate part. Okay, it's slightly less precise in its specification than on the previous occasion, for reasons which we can explore, and it has a degree of flexibility. But nevertheless, fundamentally, it is the same, and she'd be unsurprised by that. The surprising thing in my submission is that the landlord is saying, oh no, actually on those later leases, notwithstanding what I said in the first lease of the 4, not the one that's appealed, and in the second, third and fourth, is that that there is a significant difference between them, even though I've contracted to the effect that there wasn't. And this perhaps goes beyond slightly just the construction point. The first passage that I took you from Lord Justice Lewison's interpretation of contracts deals with the factual background, and we may be apart on that, my lord, but nevertheless, we're pushing in the same sort of direction over what constitutes the factual background in relation to this lease. I say the other leases on the same estate in registered titles are things which are there and available to the parties to understand the terms of the lease that they're entering into.
I'm just thinking and listening to your submission that even if maybe you were not right in saying that when one looks at the 4th lease, that tells you how you should interpret the other 3 as a matter of law and construction. I do see that if you're trying to interpret the proportionate leases, that it becomes quite difficult when you're trying to work out what a proportion is of a group when people are signed up on different terms. And so what as a matter of factual conclusion might spring from doing the proportionality exercise with the 3 leases would be to consider the fact that you actually have some people on the estate, at least one we know, who are paying an arithmetically exact amount, and that it becomes quite difficult to decide what is proportionate if you're not comparing leases which have the same terms.
Yes.
And your client happens to have a small basket that has examples of both. So I can see that at a level of extrapolation and working out what to do about this, your point might have some real purchase. But in terms of, as a matter of construction, that's a different question as to whether your primary case, which I've tried to be clear about, which is whether proportionality equals equality as a matter of construction, that's a different issue.
Yes. The one additional point I would just like to make in relation to that is one of statutory construction. That is the other page, which I've got from the interpretation of the contract, and that simply deals with the provisions of Section 45(6) of the Law Property Act 1925, which says that recitals, statements, and descriptions of facts and matters.
So where are you reading from?
Sorry, I apologise. So this is 10.71. I apologise. This is in the 3 loose pages.
Sorry, yeah, okay.
I apologise. The recitals as an aid to interpretation is, if you like, a kind of
I got it. Yep.
a last-minute thought that perhaps, well, if I'm going to be saying that recitals are an aid to interpretation, perhaps I need a little more heft than just me standing up in front of you and stating that. But 10.70, recitals in certain old deeds or evidence of the truth of the matters, has perhaps some impact there. Recitals, statements and descriptions of facts and matters and parties contained in deeds, instruments, acts of Parliament or statutory declarations 20 years older than the date of the contract shall, unless and except as they can be proved to be inaccurate, taken as sufficient evidence of the truth of facts, matters and descriptions. And what I'm really saying here is, obviously this isn't a recital referring to a document which was already old at that point. This is part of the lease, but in my submission, when one looks at recitals, when one looks at what one tenant exercising a right to buy is doing, and in the recitals it says that your lease is not going to be materially different from other leases in that right to buy context, then where there are differences between them, and the question arises of whether those differences are major differences, which in my submission my learned friend is contending for, or minor differences, and it has 2 potential interpretations, and the interpretation for the minor difference is the one that you should adopt, because that is the one which is consistent with the 4 corners of the lease that you're looking at, which says this lease isn't going to be materially different to all the other leases in relation to the estate. That is, if you like, the point that I am making, and that in that sense, and perhaps that's a better way of expressing it, in that sense this is very important, or at least significant, as an aid to construction, because it says, look, actually these are all going to be the same, and if somebody's saying, oh no, this is really very different, then that is not consistent with the terms of the lease granted to that particular individual. And in relation to 3 of those 4, we are the successor in title to, well, in fact, all 4 were successors in title.
All right. Well, shall we pick this up at 2 o'clock?
Yes.
Thank you.